Peace FM 104.3. Good to meet you.
Now, the original jurisdiction of the Supreme Court, i.e., voting right of deputy speakers.
So the original jurisdiction of the Supreme Court to interpret the Constitution. But in himself, with interpretations, you do interpretations when there is ambiguity or there is confusion. And the Supreme Court will be called upon to come and give interpretations. And now, law school be the doctrine of separation of powers. Law school be the political question doctrine. And I name things that are justiciable and things that are non-justiciable. These are basic things that it should be our law school. So, as a student of law, you are equipped with this knowledge right from the word go. It's the offer constitution. Now, the constitution also tells you, and mind you, our 1992 constitution makes the constitution the supreme law of the land. What Kelsen calls the grun norm. It's every to me and constitution is in previously the 57-69 constitutions. Now, sovereignty was in parliament. It was not within. This time around, sovereignty resides with the people, but the constitution is the supreme document. So, and I say that parliament are masters of its rules and procedures. And so, you don't get the executive interfering in the affairs of parliament. Neither do you get the judiciary also interfering in parliament's affairs. Same, vice versa. You don't get the parliament interfering in what the executive does. And you also don't get the Parliament of Ghana interfering in the workings of the judiciary. Into Obia when space Obia operating. You say one Justice Abdullah Akokot. For me, and this is my personal opinion, I am of the opinion that one, Parliament should have joined in the suit so that their voices would have been heard. Because now issues now Omokwakwa delve into it affected the domain of Parliament more than any other person. So Parliament should have joined within the suit, even as an amicus, to go and be part of it and then at least speak for themselves. Even though Justice Abdullah, the plaintiff, canvassed the position that Parliament naturally would have canvassed, I believe the second opinion from another legal perspective would have enriched the arguments that were laid, because Abdullah himself represented himself in courts. And then the position of the Attorney General was the position of government and what the NPP was seeking for in Parliament. My challenge and my difficulty is this. Article 102 on quorums forming. The language and the wording is very clear. There is no ambiguity. There is no ambiguity. Article 104 on voting of members of parliament states 1041 essay the Speaker of Parliament. Here the Speaker is mentioned specifically. The Speaker has no original or
casting votes. No ambiguity. Offer 1043 now. Say ye to abano na se paya. It will be taken say omo ye for motion, so ye for e-levy. For instance, say ko 2 e-levy aba. Na abani na ye for e-levy. And opposition NDC for near against e-levy. Ye to na 137 na paya. The decision is that omo ye for no elusive votes no. But the 104 now. So here the Speaker has no casting votes. Neither does he have an original vote. It didn't say second Speaker. It didn't say second Deputy Speaker. It just left it at Speaker. The Speaker.
The Speaker. It only left it at the Speaker. So the assumption is already the infamous granted. It is the main Speaker that it is referring to. Because the Constitution cannot solve all the problems. Then it means can't say it's other legislative instruments like acts of parliament, like procedures of parliament, like standing orders, like EIs, like LIs, so that areas are constitutional, vague,
it can come in and fill that gap. Into Uber standing orders, Nima, is it 108 or 110 or something? 109 in the standing orders. It comes to talk about the second deputy speaker not having an original vote when they are voting. The same constitution, Oko committees of parliament, I say the chairman of the committees do not have an original vote. Originally, Tuabana, we a chairman, and here the chairman was mentioned. We a chairman, I want to be. But say Edu say Apaya, the chairman is giving a casting vote. All construe now we interpreted documents. You take the whole document and interpret it. Now I've heard some arguments from some people in saying, oh, once the member of parliament who becomes the speaker, he's still a member of parliament, his vote should not be lost. Rightly so. But the same constitution tells you again, say, we are member of parliament. Now say it should be a fan ever before the house for deliberations. First, you must declare your intentions. And then 2, when it is time for voting now, even though you're a member of parliament with voting rights, you abstain from the voting. And what does that tell you? What it simply tells you is that with issues of conflict, because assembly it is all in this constitution. So I don't know how the constitution deals with the issue of conflict of interest. And I've always said, this current Supreme Court, they have not done Ghana a lot of good in many instances. Because there was a question on conflict of interest. Group will be at the finance minister, Ken Ofuriata, or court. On Ken Bond, the Mayor Franklin Templeton for bond issue be by, the question before the Supreme Court was to answer the issue of conflict of interest. If the Supreme Court have attempted to answer that question and have dealt with that matter, Mijini said would have had a proper, clear understanding on issues of conflict. But the Supreme Court refused to answer that question. So that matter was thrown out of court. Oma answer question, So, over constitution, you say, oh, yeah, MP. Now say, yeah, betuaba. Now, abane babetuno, a foul, and now we interest me, I was also declare we interest, no. Who declare interest in you are, won't mean to abanibi. You better to abanibi, but who want to be? Have you been denied your right as an MP to represent your people? Because the constitution makes that provision. So that argument say, so your first deputy speaker, now Yamana and Tuabanibia, he's been deprived. There is a clause in the constitution that enforces that, say, once you are in conflict, which means Tuabanibi. I have read the decision of Yoni Kolendi JSC from South decision, Justice Abdullahi versus Attorney General, with the issues pertaining to the Parliament of Ghana. Meaning, right from the word go, Justice Kolendi is very intelligent. So, okay, decision it is patent there. There was an attempt to push away the issue of the political question doctrine by telling us in the judgment is that question does not apply to Ghana. I beg to differ.
All my reasons.
And I'm saying, I beg. Is there only reason? I beg to differ. On any opinion, but I beg to differ.
Say the opinion. It is premised on something.
Because the political question doctrine has found space in our jurisprudence.
Okay.
It told me can say it is only known in America and not in this country, and here it is not.
Also British court.
And I'm going to say it has found space in our jurisprudence, and this is not the first time the issue of political question has made appearances in our courts.
Okay.
2, there was another attempt to create the impressions there. The independence of parliament and absolute. That is true. We all know that the independence of parliament is not absolute, but we also know, under the 4th Republican Constitution, parliament is a master of its rules and procedures. And mind you, the same judgments, and you see that is where I find very contradictory. This statement that was made, I'll say, it must be emphasized, however, that the procedural and or operational rules to practicalize the protection of this constitutional right in a member presiding in the absence of a speaker, and his or her duty to represent his or her constituents in the vote and decision are matters within the exclusive domain of Parliament itself. See, your training in it, this is how he came to conclude. So who says Parliament does not have the power to deal with this matter the way it has to be dealt with?
But okay, on the issue of Parliament being a master of its own, and that, okay, page 9 of the decision.
Yeah.
Me person me kind paragraph back up picture. I'll say, if the desperate interpretation preferred by the parties exclusively implicated the standing orders, a standing orders, I can say parliamentary master of his own, procedures and practices of Parliament, without more, we would have had no difficulty in reaching the conclusion that Parliament is and ought always to be the master of its procedures, orders, and practices without let or hindrance from the court. In such a case, this would have been matters that lie peculiarly within the domain of Parliament and will therefore not be matters appropriate for judicial determination. This one is premised on the reliefs are not Justice Abdullahi Ope, because okay, senior Unicolendi Chona GSC or Troyana or say nipa na ode na asem no buy no reliefs are not open. One, or say a declaration that upon a true and proper interpretation of Article 1043 of 1992 Constitution of the Republic of Ghana, the first and deputy speaker's casting vote is inconsistent with Articles 1043 of the Constitution of 1992 Republic of Ghana. 2. Declaration that upon a true and proper interpretation of Article 102 and 1041 of the 1992 Constitution of the Republic of Ghana, a speaker or any other person presiding over Parliament cannot be said to be part of the members present for the purposes of decision making. Now, in fact, now we know 8 reliefs. It's okay, but Yonikulendi's argument is that Senke Base, Abana, Wamoko Trans, Parliament Voco Trans, 137, 138, no Anqua. Any anka Parliament no emblem, and no the Ankobe, or Mobetimia defer the Parliament say, on fun standing orders Nanka. But to the extent that Nipano, the plaintiff, is praying and invoking the original jurisdiction of the court, or interpreting provisions of the 1992 Constitution, they cannot leave that interpretation for the Parliament of Ghana to do. What do you say to that?
Nobody's arguing on that. The starting by says that the original jurisdiction of the Supreme Court is for interpretation purposes. But when there is no ambiguity, you don't waste your time and waste the court's time.
But what kind of judgment? I'll say there is ambiguity.
Well, and I'm saying respectfully, that is his opinion. The wording in 1043, I don't know where the ambiguity lies. And you see, let me read it.
Article 1043.
43.
Okay.
1043, I'll say. Where the votes on the motion are equal, it shall be taken to be lost.
Where
the votes on any motion are equal.
That is 1043.
Yes.
Where the votes on any motion.
Is that not what
equal?
Justice Abdullahi was seeking interpretations for? Right? Where is ambiguity in this? Where the votes on any motion are equal, it shall be taken to be lost.
That's what the Constitution says.
Yes. Is there any ambiguity in this wording? Where do you say are we court no ebembe interpreted now? The Supreme Court could have declined this invitation. And you see,
but all kind 1043.
Yo.
Supreme Court no so argument ni you say there is a plentiful no.
Yeah.
All can nyina no. 1041 and now 102.
Okay, so 102.
1041.
So 102. A quorum of Parliament, apart from the person presiding, shall be 1/3 of all the members of Parliament. Where is the ambiguity here?
Okay.
And then 1041. Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present.
Show me the ambiguity.
Me person me kind be was but me refer the exact paragraph and me kind. The Supreme Court justices address that issue or say it is not for nothing Nintina or Mao quorum for Parliament on two different instances.
Yes.
You understand?
I'll get into that argument too. So you go on me too.
No, so because where is the ambiguity? I don't know.
And I make sure say is it so 102 talks about the quorum in Parliament. Or say a quorum of Parliament, apart from the person presiding, shall be 1/3 of all members of Parliament. What it simply means is that while all presiding, when the quorum is being counted, don't count. That is for 102. That is for Parliament to originally start its business. There must be a quorum as soon as Parliament it may start.
And no, it's 1/3.
And only 1/3. It's while presiding. And we are and you speaker. When you are constrained and interpreting documents, you take the whole document.
Yeah.
Here, speaker was not mentioned. What this tells you is that anybody can preside. If the days are in the absence of the first and second deputy speaker and the speaker, the members of Parliament can appoint one of them to be member presiding. That's here. So that member who will be appointed to preside in the absence of even the speaker. Can't quorum now.
That is the quorum for Parliament to begin its business.
Okay.
Okay.
And then when it comes to voting, or say except as otherwise provided in this constitution, matters in Parliament shall be determined by votes of the majority of members present. And in fact, I've seen laws, the Assembly's law, for instance, total number of members. In your crowd, you kind of count. Also, members present in the chamber, a left-out chamber, but present and voting with at least half of all the members of Parliament present. Can I say quorum to start meetings? 1/3.
1/3.
But see about 2 about on the floor of Parliament, sir. Because it's an election, it's voting. We should have more than half
of the parliamentarians,
present.
Great.
More than half.
Sure, move on.
So maybe difficulty. They say the wording here is clear.
Okay, let me ask you before you come to the clarity of your wording. Parliament also said 275.
Yes.
Half of it saying.
I say more than half.
And to me, who half.
So because the parliament means any permono, about 138.
138.
Yes.
Okay. And at that point now, deputy speaker. Presiding. Deputy speaker no oyeden.
So this is where the argument gets interesting. Once the deputy speaker decides to preside, say a kind quorum from 102. Now deputy speaker is not considered as part of the quorum. You cannot move from 102 and come to 104 and automatically add the deputy speaker.
But OJ say out of nothing, in a constitution, framers of the constitution, set two different quorum and a quorum.
And I make sure say it flows from 102. Or say for business of Parliament to start, you must have 1/3. 1/3 of 275 and 138. It's less than that. But see about 2 bar. But right from 102.
By the time no constitution, now you require 245.
No, 245. Granted. I'm only looking at it.
Sure, I understand.
So say you about 2 bar. At least because elections are important and can affect many more people. At that material moment, at least more than half should be present to vote. But mind you, 102 has told you say can't quorum now while presiding on count.
But what of 1041?
1041 is what I am reading. 1041 said present and voting more than half. So flowing from 102, what I think with my understanding of the law is that because 102 takes out whoever is presiding, it is in the same vein, and a 104 doesn't factor while presiding.
And my layman's understanding is that Senka framers of constitution per se 1041 fana ho di free 1042 now they will have referred and come on 32 different quorum.
No, you see, so when you are for your interpretation, mind you, the constitution has a spirit.
Okay.
So I say, the constitution has a spirit. So you read the whole document to reach the interpretation. So over 102, 104, 1043.
And now we jump 103.
Was it
1041?
1041. You take it. Over 102, over 1041, and then you take 1043. That says say a paya.
Because, mind you, it would have also considered the role of the speaker, say, or your member presiding, the role he can also play in voting. Because, mind you, the same constitution at the committee level say the chairman of the committee has no original votes.
But he has casting.
Maybe he has no original votes. Offer standing orders, it takes away the original votes. Standing orders is it 108 or 109? It takes away the original votes for the second and first deputy speaker.
For when they are chairing,
when you are chairing and you are seated in the chair as a presiding, it takes away your original votes. You know why? Because from my understanding of the law is that because you would have been in conflicts if you are presiding, for you to also jump in and come and vote. For instance, see a voice voter. The speaker is supposed to listen, and mind you, parliament votes in Bia, and apart from election of the speaker, it started from voice voters. If that one doesn't work out, then they go for the election and then do the secret vote to say voting by hands. No, it's mind you, say, oh yeah, speaker. Na utijemu. Na yesu me tuaba. Na ye voice voter. Na wakasa vote bia. How would you decide whether the A's or the I's or whether the no's and the yes have it? How would you decide?
Okay, the Supreme Court says something in their decision. We have point 2 or say, okay, my main crime free. The last paragraph of point 1. I'll say that is to say that a presiding deputy speaker is entitled to be counted for the purposes of forming a quorum under Article 1041 of the 1992 Constitution. That upon this point 2, that upon a true and proper interpretation of Articles 102, 1041 of the 1992 Constitution, a deputy speaker or any other member of Parliament presiding over Parliament in the absence of the speaker can vote and take part in a decision by Parliament. That is to say that a deputy speaker or person presiding other than the speaker does not lose their right to vote when they are presiding over proceedings in Parliament. Accordingly, Order 1093 of the Standing Orders of Parliament is struck down as unconstitutional, and the same being inconsistent with the contravention of Article being inconsistent with and in contravention with Article 102 and 104 of the Constitution. In fact, before more is okay preamble no bana or say sa a Ghana ya was a Article 2 pakoto Article 2 akache say and no nature and say yemre kunini ayewo and it's a constitution.
I made the same argument.
Yes.
Nobody is disputing.
Emre bia yebeye Ghana ha no say she kukum ehye sehwehe ehye anwanwan ene fa no ofa na ho odin fi 1992 Constitution.
Nobody is disputing that either.
It is a koye mre bi say we are master of your own. Now because of that notion into no we mra na say obi be invoke original jurisdiction of the court no say o mra na waye no say o de na ho de no ko free constitution no aba ene constitution no nko enti entwamu a eno omo be ho adwuma eno nti na o ka kire say o ma strike sa your friend saying order one free standing orders no because its root in the constitution cannot be guaranteed, and because it is unconstitutional according to the dictates of this constitution, it is declared null and void.
When they wrote this beautiful flowery language, this is how they concluded. Same judgment. It must be emphasized, however.
Then how can you point?
You're only calling the points now. I just called this one out. I say it must be emphasized, however, at the tail end of the judgments. It must be emphasized, however, that the procedural end or operational rules to practicalize the protection of this constitutional rights in a member presiding in the absence of a speaker and his or her duty to represent his or constituents in the votes and decisions are matters within the exclusive domain of Parliament itself. What's it here? Voting rights now, procedures now, and no one someone or can know. And no one someone or can know. Also, it must be emphasized, however, that the procedural or operational rules to practicalize the protection of this constitutional right being voting once and no can. In a member presiding in the absence of a speaker and his or his duty to represent his constituents in the vote and decision are matters within the exclusive domain of parliament.
Okay, my main kind be was na reconcile two near here.
Mate.
Oh, now you're lawyer. Me there. Patcho, me there be a quanchen you.
Oh, there be. It's a good intellectual discussion.
Quanchen lawyer. Don't I lawyer, Papa? Patcho, person me kind be free page 23 of their decisions na here. Or say, in our view, the fact that the speaker alone is disqualified from voting in all circumstances, while members of parliament, which includes both deputy speakers, are disqualified from voting only on a contract where that member has a specific conflict of interest, lends the necessary clarity to the following two propositions. Firstly, the speaker is disqualified from voting not because he or she presides at sittings of parliament, but because the speaker is not a member of parliament, voting being a right only for members of parliament. 2, presiding at a sitting of parliament is not intended by the framers of our constitution to be disqualifying conflict of interest, and therefore a presiding deputy speaker does not forfeit his or her right to vote merely by virtue of presiding in the absence of the speaker. Furthermore, we are of the considered opinion that these voting disqualification rules highlights a crucial point. Members of parliament sit in parliament as elected representatives of their respective constituencies. Parliament operates on the standard democratic principle of equal representation, or one member, one vote, with matters decided by a majority vote. Therefore, to cause a member to forfeit their vote in parliament merely on account of having to preside over the business of the house in the speaker's absence would unfairly disenfranchise not only the presiding member but also their constituents. Such an interpretation will likely give rise to certain perversive outcome and or incentives. For example, it could lead to opportunistic absence by a speaker or one of the other speakers, as an absence will mean a vote loss by the presiding member when a member and their party, in particular, Article 96, blah, blah, blah. How do you reconcile this with your position?
This orbiter was very unnecessary.
Why?
I'll tell you why.
Tell me.
Nanaya,
Papa.
If he acknowledges the fact that when you are in conflict because of over a contract, which may be serving your personal interest, which bigger conflict and the chance say me empire I'm a Tehanomo. Now me decide say either the yes or the no's have it. Which conflict and associate no? It's me say hey. Now I'm here first deputy speaker of parliament. I'm a near Hodachi. Now I'm here first deputy speaker. Now we are putting it because in parliament the first vote are a voice vote. It is when there is misunderstanding and they are subjecting it to election. It's me now yeah me will vote immediately I start shouting. Can I hear myself?
Do you think the parliament is here? Ubibeji voice vote at all?
About many decisions have been passed by voice votes.
Those are not controversial votes.
And I make capture, but you see, that is the we cannot pick and choose.
Yeah, we can in this case.
What it is today, whether we like it or yes, the first option for voting is a voice vote. In the last 30 years, the 4th Republican Parliament, a lot of major decisions have been taken by voice votes. Voice vote is not alien to our laws. Inti no say, yeah, voice votes. Na me na me speaker na me timu no. Na me ame tiamu bi yeah. And I know and I know. How would I hear myself? I will come back and say the Ameme Kaino was the highest. There is not a bigger conflict of interest than this. But the good news is that this decision from this current Supreme Court, let this same case in the next 10-15 years go before another Supreme Court. I can be confident in my heart say they will not return with this verdict. As for this verdict, I have tried to make sense of the judgment. They come to conclude say that protection of that voting rights so that the presiding now what I represent to constituents it lies within the domain of parliaments.
But
what do you understand that statement?
No.
Even though they claim that they have striked or they are here out, they still acknowledge the fact that it is only in parliament that this can be cured.
Or see, regarding vote no say 137 echo rejected budget no. Now 138 is also ba say o ma beji atum sa asem no. Tena me kan paragraph o se senke no and ni pande ba court and go ho because in the parliament na betimi akle. But so long as our constitution asem 1021 1041 no ese so mo bam.
Nana yo biji tum. They've dealt with all this. Now with all the flowery languages on Motroy, no. They come to conclude by saying say start to practicalize say a bit me about real into practice no. It lies within the domain of parliament. And no, they couldn't give consequential orders. So, mind you, the Supreme Court is clothed authority to give orders.
But will you fault the Supreme Court when Nipa no wade na asem koye no? Ono ankasa wo hwe ne relief a o siki o ayina. Why can't constitutional provision? And if I hear relief 3.
Nana, you misunderstand me.
Okay.
I am saying that Supreme Court, your original jurisdiction is to interpret the Constitution. So if anybody comes before it with issues of the Constitution, it has every right to do what it did.
Okay.
The conclusions they arrived at is where I have a problem. Conclusions not arrive here, no, because you see when they are interpreted document.
If your problem is the Constitution, it means that we know they will depart from a more say Parliament here, master of your own rules and think. But
the Supreme Court concludes by saying that statement kind. They conclude by saying that.
But those making that argument, as they say, because Parliament here, master of that of its own rules, you know, none can say Supreme Court no entertain sorry to what can I say?
But I started by saying that if I was a judge on the Supreme Court, I would decline jurisdiction on this matter.
Even when somebody seeks clarification in Constitution,
because there is no ambiguity in the wording. So based on that, I started my argument by talking about ambiguity. Because the Constitution says, one, if there is ambiguity. Two, if you think a law contravenes the Constitution. Now, mind you, the young man who went to court, Justice Abdullah, he didn't go to court on the orders of Parliament. Too. Parliamentary orders, now they call court. Too. He went to court seeking constitutional interpretations. So when I was expecting the Supreme Court to tell him, there is no ambiguity in this wording.
Okay, who determines whether there's an ambiguity or not?
The courts have the right to determine.
So they have determined.
And I make us say, I have read, and I mean, there was a 102 forming of quorum. Where is the ambiguity in it? The decision has come from the Supreme Court. But and this is the first time Supreme Court decision. Almost everybody is poking holes in it. Because that is not what the law should have been. But you see, you cannot fault a judge when he comes out with it. And I'm say, same evidence, same facts. We have 5 judges. 2 will speak for, 3 will speak against. Until everybody and his understanding of the law. What I want to believe is our current Supreme Courts, their understanding of the law is what they have done. Because we've seen decisions, everyone that Tibano Supreme Court, no, we've read decisions from that bench. Decisions, we've read them. So for Yakufunum decisions, we've read them. And currently, we are reading the decisions that are coming. Now, this is about 24 pages, 25 pages. We've read 90 pages, 140 pages. Cogent arguments. We've read all. But the Supreme Court's position in the last 4 years, assistant Bibri. But hey, who am I to say anything? Okay. That is the Supreme Court. But I can assure you, most of the decisions they are turning out today, someday in the future, another bench will sit down, same issues, and they'll rule differently. Because you see, my understanding of the law and how laws are interpreted, no. Decision, especially on the issue of conflict of interest. If an MP can be disenfranchised from voting because he's in conflicts, and then you tell me, a presiding member who sits as an umpire, who is going to decide a yes or a no vote based on the anipade team account or not to team be.
That
is the first vote in Parliament.
But not only.
You don't move apart from election of speaker. Apart from the election of speaker, I know right from the word go, you got to the French, every other issue. Voice vote is the first instance.
But no, your first instance.
And I make catch us,
yeah.
That is the first instance, whether we like it or yes. It is only when there is dispute over the voice vote, and I am subjecting it to other,
Professor William Bamboatin, thank you for your input.
Peace FM 104.3. Good to meet you.